Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today I have three guests. Lisa Lerman, Professor of Law Emerita at Catholic University Columbus School of Law. Philip Schrag, Delaney Family Professor of Public Interest Law at Georgetown Law School. And finally, Rob Rubinson, the Gilbert A. Holmes Professor of Clinical Theory and Practice and Director of the Mediation Clinic for Families at the University of Baltimore School of Law. And fun fact, as we were getting ready for this podcast, I came to find out that Lisa and Philip are also husband and wife and are approaching their 40th anniversary. So why don't we start by, Lisa and Philip, why don't you tell us why it is you all first started to think that there could be an opportunity to write a book in legal education, and what book you wrote and why?
Why don't I start? So I've been teaching professional responsibility most years and most semesters since 1984. I'm not teaching anymore, but I taught for a long time. And I felt like early in my career, I heard David Luban give a talk about, it was called 12 Ways to Fail as a PR teacher. And I went, it's not me. It's really something about the course that makes that it's marginalized in the curriculum and the students don't take it seriously and the pedagogy hasn't been worked out. So that launched me on a multi-decade campaign to figure this out. And then along the way, another Aspen author, I think Aspen, asked me if I wanted to come on to his book. And I came home and Philip in the kitchen said, well, honey, if you're going to do all that work, don't you want to write your own book?
I love it.
And then within a week, one of the Aspen acquisitions people was in my office starting a courtship. And then eventually I realized that I desperately needed a co-author, made a list of about 100 people I could have worked with. And Philip was my number one choice. And I'm glad I felt that way because it worked out well.
Well, in co-writing and in life, right? So he was your number one choice. At some point in the writing of Ethical Problems in the Practice of Law, you brought on some co-authors. You're now in the 7th edition, so why don't you share who your co-authors are?
Okay. Philip and I did the first 4 editions, just the two of us. And then we needed another person. So then we recruited Rob Rubinson, who's with us today. And then for the 7th edition, we realized that we're not getting any younger. So we invited 2 other people, G.S. Hans, who's at Cornell, and Ali Luciani, who is an associate at Covington, to join us for the 7th edition. And they're not here today, but they did a tremendous amount of work.
Rob.
So when Lisa and Phil asked me to join, I actually was a happy adopter of this book after cycling through 3 other books when I first started to teach professional responsibility some 27 years ago. I had the pleasure of using the book before I became a co-author, understood its many, many advantages, and was honored and so pleased to be involved in subsequent editions.
Well, let's start there, Rob, since you were an adopter before you were a co-author. What set this book apart from the others you had tried in teaching PR?
Problems. I mean, PR is a fantastic, engaging course because we're speaking to law students who are about to become lawyers and they need to understand what lawyers actually face in practice. So we don't offer fact patterns. We offer problems, which are rich in all sorts of different dimensions, including practical ones, including complex analyses of ethical rules and reading cases and the Socratic way, which of course can be effective, just doesn't lend itself to either engagement on the part of students or in them learning about how to grapple with real issues once they graduate. So the book just, sorry if this sounds corny, but kind of spoke to me and how I wanted to teach this course. It just was a perfect fit for me.
That's great. And Phil, you were, or all 3 of you are clinicians. And Phil, you were one of the first clinicians nationally when the clinical movement was started. Is that what prompted you to draft a book based on problems?
Very much so. Of course, for clinical courses, problems are the meat. They are what everybody works on. What we did in this book is something different than one of your previous interviewees, Doug Whaley, did in his problem books. He used problems that were based on hypotheticals. All the problems, or nearly all the problems in this book, are based on what actually happened in real life to real lawyers. But we don't tell the students that until the end of the discussion. So the students get the problem at the moment that it existed, at the moment it originated for the lawyer. And the students are put in the shoes of the lawyer at that moment when the lawyer had to make an ethical decision that would influence the course of the problem from there on. And the way that we encourage students to teach this course is to have the students prepare the problem on their own and then meet in small groups of 3 or 4 or 5 students in the classroom to discuss the problem for a few minutes before they share their answers or their ideas about the problem with the large group. The purpose of that is to give them self-confidence, to let them test out their theory of what they would do, hear from other students, and before they have to speak to a larger group of students, see whether it makes any sense or not. And then what I do in my class after the small group discussions is I use electronic polling to have the students register what they would do, a bunch of multiple choices on a screen as to what they would do next, and they vote. And la-da, the screen lights up with the results. And often, if there are 2 choices, it's 50-50 or 60-40. Or if there are 3 choices, it's 30-30-30. And the students then realize whatever they voted, they're not alone. There are a lot of other people who share their ideas. Then we have the plenary discussion of the pros and cons of each of those choices, with somebody who voted for each choice discussing the advantages of that choice. And then finally, after the discussion has been finished, the teacher tells what happened in the real case, whether the lawyer won the case and was praised for his ethical decision-making or ended up in prison or somewhere in between, disbarred or suspended. How do the teachers know about all of this? The book comes for teachers with a 400-page teacher's manual, the only printed teacher's manual that Aspen has for any of its textbooks. It's also online on a password-protected website. And the teacher's manual gives the teachers details of what everybody might say in the class about every problem, all the pros and cons of each approach. So effectively, it works as class notes for the teachers. The teachers can actually take the material off the website and transpose it into their own class notes, adding what they like, taking away what they don't like, and so forth. And the website also has 450 slides that they can adapt to their own use, as well as recordings of the actual lawyers who handled some of these cases, interviews with those lawyers. And finally, the teacher's manual has the description of what happened in the real case, so the teachers can use it as the reveal at the end of the discussion. And many of those revelations are incredibly shocking and surprising.
I love the reveal, and I wondered that after that aha moment in the first case or two, or first problem or two, do the students start to try to find the answer for the rest of the problems? Do they figure out that, there will be a real lawyer at the center of the problem?
Well, they all know from the get-go that these cases are based on real events. We tell them that. It's hard for them to research the actual cases, though, because we've disguised the names and transposed the locations and so forth so that they can't really get prepared for class by looking up the result. And that's been successful so far. The students seem to come to these problems pretty cold and flounder around for a while before figuring out what they're going to do.
Sounds like a really fun way to learn. Lisa, do you have anything to add?
Yeah, I was going to mention that the students, I don't think I've ever had somebody find one of the problems as a real case before class, but they do get the work of analyzing the problem is sort of the hard part of class. And then hearing what happened in the real case is like dessert. And I think that they do get into the rhythm of looking forward to hearing what really happened. And it's one of the things that motivates them to do the work on the problems.
Rob, once you started to use this book, how did you find, obviously you enjoyed it, but what was the specific difference you saw in the classroom as opposed to the other books that you had used?
A lot of the advantages of this book, and there's drama to it in terms of the big reveal that just encourages students to be engaged, as well as the polls We worked very hard to make the problems compelling, sometimes timely. And as I taught the problems, I could absolutely sense greater engagement on the students' part. Again, a Socratic discussion of cases has its virtues, but in a class like this, I just don't think students will be as engaged as they are with this. There's a kind of value in getting excitement into the material, and I think the book achieves that. And I certainly felt that when I first adopted it.
Some of the best problems in the book have come to us from other adopters of the book, people who've used it in the classroom and know about some extremely interesting ethical problem that has occurred in their jurisdiction or in their state.
Well, that's very cool.
One of them came from Professor Alexandra Lahav, who's been a guest on your show, and it's exemplary of how interesting these problems are. Lisa, do you want to describe that problem?
No, you do it because you
Okay.
just
The problem occurred, the actual case occurred in Connecticut. The technician for a highly respected Episcopal church came to the rector one day and said he had discovered on the laptop of the church's choir director a lot of child porn photos. And he handed the rector the choir director's computer. And the rector was astonished and shocked and called in the church's lawyer and handed the lawyer the computer. So you're the lawyer. You've just been handed this computer with child porn on it, which is illegal to possess. The church's choir director has just resigned suddenly, and you have this computer. You don't know of any investigation that's been started of this, but what do you do with this computer? That's the problem. And the choices that we put on the screen for students to choose among include handing it back to the choir director because it's his property, insisting that the rector keep hold of it because if it's kept in the lawyer's office, it's unlikely that a search warrant will be issued for it, so the lawyer could be said to be concealing it. Keep it in the lawyer's office where it's less likely to be found, turning it over to the FBI, trying to erase the files, destroying the computer, or just what? And the students have all those choices to make.
I can't wait to hear. What should you do? What should they have done?
Well, there is no clearly right answer to this because the law at the time, and still is, that generally a lawyer has no obligation to reveal possession of contraband material unless the lawyer knows that an investigation is pending or likely to be started in the near future. And the lawyer had no reason to know that there was any government investigation at all. Now, in the real case, it turns out that an investigation had begun the day before all of this happened, but nobody knew about it. So the lawyer destroyed the computer. He
with a
smashed
hammer.
it. Pardon me?
With a hammer.
With a hammer. He smashed it with a sledgehammer.
That's terrible.
Later-
That would never be the choice.
Later, he was accused of violating the statute prohibiting obstruction of justice. And this was the first time ever that somebody had been charged with obstruction of justice without a claim that the lawyer knew that there was an investigation that was likely or had started. So there was a negotiation between the lawyer and the government. The lawyer was terrified. The lawyer had been a president of the local bar. The lawyer was a very upstanding lawyer, but he was terrified about going to jail. And he finally negotiated it down in a plea bargain for the crime of misprision of a felony, which is a rarely prosecuted crime. It's almost never prosecuted, meaning that you have knowledge of a felony and didn't report it. So he was convicted of that, and his bar license was suspended for a while. That's the reveal. But before you get there, the students have to struggle with this marvelous case and about 45 other cases that are in the textbook for students of equal interest that are in this textbook for students to have to grapple with.
Well, you got me on that one. That is fascinating. And if that's just one of 45, I might just order this to read. Lisa?
Yeah. So one juicy little detail that makes the story even more jaw-dropping is that the church where this happened is an Episcopalian church, I believe, that's in Connecticut, where George H.W. Bush went as a child. And we have, among our slides, we have a beautiful photo of the church. So you can see that this is not some, marginal, struggling congregation that hired a ne'er-do-well. This is like the upper crust. which
You
is
said you might order the book to read it just because it might be enjoyable. In fact, we got an unsolicited message from a professor at Seton Hall, Professor Jamie Werbel, who wrote us, "I wanted to drop you a line to let you know how fabulous your textbook is. I just started teaching professional responsibility this year, and your book has been invaluable to me as I guide my students through the course. My husband, also an attorney, made fun of me last semester, as a few times I was reading it at night in bed. It is really just that enjoyable to read."
Love it. Rob?
In terms of the enjoyability of the book, there are cartoons in it, New Yorker cartoons, to illustrate different points. And also, within the text of the book, there is a discussion of specific rules and also 4 examples which illustrate different rules. And we're careful with what we choose, compelling issues, compelling circumstances for example. So the book is a whole package. The core are the problems, but there's also a lot of material which explain the operation of different rules, the policy underlying them, not only rules, but other law and restatement and so on, for examples, and then the problems, which ultimately are the core teaching.
And the narrative material is presented in Q&A form, making it very easy to digest. So there's narrative, examples, and then problems.
So I'm going to ask the dreaded question that students would be curious about, and that is, how do students who take the course using your book, Ethical Problems in the Practice of Law, 7th edition, do on the MPRE? Do you see any difference?
They do fabulously well, in part because the book has a supplement that prepares people for the MPRE. The book supplement is called Ethical Problems in the Practice of Law, Model Rules, State Variations, and Practice Questions. And like all the supplements for this course, it has the model rules in it. But our supplement has more than 130 practice questions in MPRE format at the back of the book with answers. And so students can self-test themselves without having to buy an MPRE prep book. And what I do in my course is I have 3 sessions spread throughout the course after each of, say, 4 chapters, after we've been through 4 chapters of the book, in which I get on Zoom with them and we go over some of those MPRE questions as an add-on to the course, and we do it with polling, as I do in class. So the students who are online take the poll, the results are on their screens on Zoom, and then I ask somebody who got it right to explain why they got it right and why the other answers are wrong. And I never call on anybody who got it wrong. So everybody feels good about these sessions.
Rob, have you found that your students do well using this book on the MPRE as opposed to the prior books that you had used?
Absolutely. I mean, I can't compare necessarily. Well, first off, I used the other book so long ago, I don't even remember. This book is so much better. But I get lots and lots of feedback from students about how the course helped them with the MPRE. So absolutely, no question.
Well, having the problems the way you do and having students struggle through them themselves is such great analytical training for those questions, not only on the MPRE, but in practice. So what's new in the 7th edition that those who might have used a prior edition might be interested in hearing about?
One of the things that's very new in the 7th edition is a much expanded section on government lawyers. The Trump administration has given us a lot of new material in that respect. The attacks on the law firms are discussed in the new edition. The dismissal of the prosecution of Eric Adams, the mayor of New York, which caused the resignation of many Justice Department lawyers because they were fed up with the way that the White House dictated dismissal of the prosecution in exchange for Adams' apparent willingness to help with immigration deportations. It has material on the Stop the Steal efforts by lawyers who engaged in unwarranted litigation to try to prevent the election of President Biden. It has the firing of Erez Razumi, the lawyer at the Justice Department who told the truth to a judge that Mr. Abrego Garcia had been deported by mistake, and other examples of government lawyers who faced ethical problems, many of whom ended up resigning.
I just wanted to interject here that the book is widely used at many different schools, including some schools that have a more conservative philosophy. And we are very careful. We do have, I would say, something of a tilt in our our choice of materials toward encouraging lawyers to think hard about their responsibility to help other people and to do socially useful work. But we're pretty careful about anything partisan and this has been a challenge because we willingly include examples of misfeasance by people all over the political spectrum. It's just right now there are a lot of examples coming out of the government.
And this is not new, really. Bill Clinton is in the book as in one of the problems involving the Paula Jones case, actually, and that was brought against him. And that becomes one of the problems in the book. You are Paula Jones's lawyer, and your client comes to you and claims that the governor of Arkansas has molested you. What do you have to do to investigate that claim? Can you just go sue the person who's now the president of the United States without any further backup? Then your clients say so. And if you're going to investigate, what would you do? Would you, for example, have to call up the president and ask him whether he molested this woman? Would you have to contact her friends and see whether she has a reputation for honesty or dishonesty? Would you have to see whether she's involved in other lawsuits? Would you have to scour the countryside for witnesses? Would you have to find out whether any other women in the state had similar contacts with the governor of Arkansas? Or what? That's an ethical problem. And of course, there's a real case behind that with a reveal at the end.
One thing that Phil has mentioned is the pronoun is you. You're not analyzing virtually all the problems there on the second person, right, about that, where you're the person who is placed in the role of lawyer. So you're not analyzing what someone else did. It's your choice. And I think the descriptions that Phil has described are perfect examples of that. What are you going to do with the child porn computer and so on? That puts students in role, and it's exciting for them. They're not only reading a case about what has happened, it's forward-looking into something that's happened, and then what are you going to do about it? And as Phil has said, then there's the big reveal about what actually happened in a particular case.
I love that they're put in the shoes of the lawyer, and I imagine that's helping them not only learn the ethical rules, but it's helping with their professional identity formation as well. You're to be applauded that you've carved out the analysis for the students in a way that puts them in their shoes of a lawyer. So congratulations on the 7th edition of Ethical Problems in the Practice of Law, and congratulations to Ali Luciani and G.S. Hans, who were unable to be with us but are also co-authors. Before we conclude, I wonder if I could get each of you to share with me what your predictions are for the future of legal education in the coming decade. And why don't we start with you, Rob?
I was hoping I'd be last, but, well, first off, there's a technology, of course, which is on everybody's mind, AI, and I can assure all adopters AI was not used in the production or the writing of this book. It was all us.
We do have a section on AI in the book.
Exactly. And that, of course, is an evolving issue. But as the profession evolves, law school will also have to evolve along with it. And as generations work through, their needs, their commitments vary. And I think law schools are going to have to adapt to that. It's an exciting moment despite everything that's happening. And I think law schools will really increasingly have a role in, as you said, professional identity formation as well, and thinking about what kind of lawyer folks want to be. I think the book is an example of encouraging students to think through that.
Great. Lisa?
Yeah, we're at a strange juncture in the history of our country, and the very existence of our democracy is under threat, and the respect for the rule of law is kind of on shaky footing. And a lot of things that many of us have been working to bend the arc of justice in the right direction for decades are right now kind of going back in the wrong direction. And eventually the pendulum will swing, and there is going to be, it's almost like a hurricane that's hit the United States. And there's going to be a tremendous amount of work to do, to some respect for the court, respect for Congress, and some actually common values about what facts are and what the law actually says. And I think that's a daunting challenge, but there's certainly plenty of work to do.
It seems to me that the trend in law schools is going to be even more than it has been in the past in the direction of experiential education. AI is going to change traditional research. Schools will have to teach students how to use AI properly, and it's going to get better, of course. to do traditional legal research. And AI will also make transactional work much simpler by creating forms for everything. But what will be needed more is exercise of judgment and exercise of skill. And teachers are going to have to adapt to provide more experiential education in those directions. But that's expensive. To teach judgment and skill is not something that you can easily do in a class of 80. It's something that requires a more hands-on small group education, which is more expensive. And at the same time, Congress, in the One Big Beautiful Bill passed in 2025, has limited federal loans to $50,000 a year for law students, not indexed to inflation, at $50,000 a year. The cost of attendance at law schools, at many, many law schools, is more than $50,000 a year, which is going to require students to borrow money from private lenders at higher interest rates and without the possibility of forgiveness. And I think that's going to mean a much higher concentration of wealthy families sending their children to law schools, and that's terrible. We're going to have less economic diversity in our student populations unless something changes. And I think the combination of higher costs to teach students well for the legal needs of future clients and the restrictions on federal lending are going to create a crisis for legal education in the not very distant future.
Well, thank you so much. Yes, you have identified problems that keep deans up at night. Thank you, Lisa Lerman, Phil Schrag, and Rob Rubinson for joining us and talking about the 7th edition of Ethical Problems in the Practice of Law, which I'm going to order so that I can read all these fun problems that you talked about. And if you've enjoyed the conversation with these thought leaders in the Legal Academy, you can listen to additional episodes on other podcast channels, on the Aspen Leading Edge webpage, or on YouTube. Thank you.